Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today we're going to talk about what not to do with the title of your house. Before I get into that, I want to give you my contact information. You can find me on my website, www.amandarocalaw.com. You can comment down below with questions or suggestions for other videos, if this platform allows you to do that, or you can find me on social media at Amanda Rocha Law. So, what are the big no-nos when it comes to your title? First of all, there are many, many things that you should and shouldn't do. This is just a few things that I commonly see. In fact, I just received a potential client call last week with one of these issues, which is why I thought it would be important to share it with you. The first and most common thing that I hear people ask me about is whether or not they should add their children to the title of their home so that they can inherit it one day. And the thought is genuine. It's a great idea. You want to leave your home for your child or children, and that's wonderful. And you should and can do that. However, adding their name to the title has a lot of drawbacks. One of those is capital gains taxes. And you do not want to inadvertently give your child a ton of taxes to pay when you are no longer there and able to be a part owner of the home. And instead, you can pass it to them, completely avoiding that. We're talking thousands of dollars to the point where they will probably, most likely, have to sell the home in order to pay for those taxes. So no, do not add the name of your children to the title of your house. There are other ways, and one of those ways is using a trust to pass along your property to your children, either when you are incapacitated or passed away. That brings me to my second big no-no when it comes to title of your house, and that is when you create a trust, it is so important that you actually fund that trust by changing the title of items that you intend to put in there. Actually change the title to the trust. So what I see fairly often is a client will come into me with their documents when we first start working together and will say something along the lines of, I had a trust done years ago. I never transferred title of anything into it. So here they are for 10, 20, 30 years at times, thinking that they have a trust that's going to help them, when really they've never funded it and they've never actually transferred title of items into their trust. So it is a huge, huge thing that you actually do that crucial step of changing the title of your home to your trust. Otherwise, it isn't changed and it's going to pass as if you didn't have an estate plan. Probate in California will most likely be necessary. And the third thing I wanted to hit on today about what not to do with title of your home is if you have multiple owners and they are not a spouse or a sibling or somebody who is very close to you, it is important to know that the way you have your name and their name on the title will determine how that piece of your property, so let's say you own a third of it, will be passed along when you pass away. If you have it owned as tenants in common, which for non-married couples, this is what generally happens, your portion, whether it's a third, a sixth, an eighth, half, whatever, will be passed along to your heirs when you pass away if you don't have an estate plan. If you have an estate plan, it'll be passed along to whoever you say it goes to. However, if you own it as joint tenants with a right of survivorship, then your portion immediately, the moment you pass away, by operation of law, is given evenly to the other people who own that property, if it's owned evenly. If it's not owned evenly, it's a little bit more complicated, but either way, your portion will not be passed along to your heirs or your beneficiaries. It will be passed along only to the other people who jointly own that home, and there's nothing that your heirs or beneficiaries could do to change that, aside from perhaps a really rare argument that you were coerced into doing that, and that is almost impossible to prove. So to recap, 3 things that I see commonly either being asked if they should do it or have already done it that I do not recommend doing are: 1, do not add the names of your children to the title of your home directly. 2, definitely make sure to fund your trust with your home if you're going to do that. And 3, make sure you understand what the title of your house says and how you own it, and if you want it to pass along to your heirs or beneficiaries, that you do not have it as tenants of joint tenants with a right of survivorship. If you have any questions about this, please feel free to comment below if this platform allows you to do that. Send me a message on social media. I'm at Amanda Rocha Law, or go to my website, www.amandarocalaw.com. There you can schedule a strategy session right on my calendar. We could talk about your situation or your question, or you can submit a question on my website as well. Thank you.